get ready for the dictation on the count of 3, 2, 1, start. It is further mentioned in clause 2104.3 in most specifications for road and bridge work that dewatering where necessary for laying concrete shall be carried out by adopting any one of the following procedures of any other method approved by the engineer, and in this para as per point 3 specify that water table is depressed by well point system or other methods. As per most specifications para 2108, the unit rate for excavation includes all the works as given in respective sections 2101 to 2107. The learned single judge further ignored clause 304.3.3 of the most GTS of the contract agreement, wherein is clearly specified as follows: dewatering and protection, normally open foundations shall be laid dry where water is met within excavation due to stream flow, seepage, springs, rain, or other seasons. The contractor shall take adequate measures such as bailing, pumping, constructing diversion channels, drainage channels, bunds, depression of water level by well point dewatering, coffer, dams, and other necessary works to keep the foundation trenches dry when so required, and to protect the green concrete masonry against damage by erosion or sudden rising of water level. The methods to be adopted in this regard and other details thereof shall be left to the choice of the contractor, but subject to approval of the engineer. Approval of the engineer shall, however, not relieve the contractor of the responsibility for the adequacy of dewatering, the protection arrangements, and for the quality and safety of the works. Another important clause which was not considered by the learned single judge was clause 304.5.1, 4 and 5 of General Technical Specifications for road and bridges, which provide that the contract unit rate for the items of excavation of structure shall be payment in full for carrying out the required operations, including full compensation for 4 foundation sealing, dewatering, including pumping, when no separate provision for it is made in the contract. All labors, materials, equipment, safety measures, diversion of traffic, and incidental necessary to complete the work to specifications. The learned single 1.2 judge further overlooked provisions of Technical Specifications Section 5 clause regarding site information, which provided in clear terms that the information given hereunder and provided elsewhere in these documents is given in good faith by the employer, but the contractor shall satisfy himself regarding all aspects of site conditions, and no claim will be entertained on the plea that the information supplied by the employer is erroneous or insufficient. In addition to above, clause 7.1 in Volume 1, Section 1 of the contract agreement provided for site visit and states that the bidder at the bidder's own responsibility and risk is encouraged to visit and examine the site of works and its surroundings and obtain all information that may be necessary for preparing the bid and entering into a contract for construction of the works. The cost of visiting the site shall be at the bidder's own expense. It is submitted that through contractual clauses quoted above, the appellant had made it absolutely clear that all expenses, including compensation for dewatering by employing well point system, were all inclusive in the unit rate for the items as quoted by the bidder, and therefore no claim in this regard can be entertained later on. Not only this, the bid document specifically instructed the prospective bidders to visit the site and familiarize themselves with the site conditions, including, though not exhaustive, soil conditions, climate conditions prevailing in the site area, extent of rainfall, and other geoclimatic conditions which were necessary to be taken into account for the purpose of preparation of financial bid